This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why an arbitrator's factual error must stand, and that the arbitrator's factual errors are never grounds to vacate an arbitration or appraisal award. In Martinique Properties, LLC versus Certain Underwriters at Lloyd's, London, a decision of the Eighth Circuit United States Court of Appeal on March 1, 2023, the Eighth Circuit interpreted the Federal Arbitration Act as it applied to an insurance appraisal. Martinique Properties, LLC sued the underwriters, seeking to vacate an arbitration award. The district court dismissed the complaint for failure to state a claim for vacatur. Martinique Properties, as expected, appealed. Martinique Properties owned apartments in Omaha, Nebraska, for which it had property insurance through the underwriters. In May of 2016, while the policy was in effect, the apartments sustained hail and wind damage. Martinique Properties submitted an insurance claim for reimbursement of its repair costs, and the underwriters and Martinique disputed the amount owed for the repairs. The insurance policy included an appraisal provision which governed the process for resolving disagreements as to the amount of loss or the value of the property. Under the provision, a panel of appraisers was to evaluate the property damage and determine the amount of loss. If the panel came to a decision, its agreed-upon appraisal award would be binding on the parties. Martinique Properties invoked the appraisal provision. A panel of appraisers agreed on a binding appraisal award in June of 2020. The suit against underwriters sought a declaration that the appraisal process and award were invalid. According to Martinique Properties, the award incorporated incorrect figures and measurements. The district court granted the underwriters' motion to dismiss, finding that none of Martinique Properties' allegations presented appropriate grounds for vacatur. The Arbitration Act is a congressional declaration of a liberal federal policy favoring arbitration agreements. Under the Act, a court may only vacate an arbitration award in 4 very limited circumstances, and in the absence of one of these grounds, the award must be confirmed. Martinique Properties argued that the appraisal award must be vacated because the appraisers used figures and measurements which are contrary to the actual conditions of the property, and failed to consider certain buildings and certain portions of a damaged roof when determining the appraisal award. Martinique Properties' only factual errors that they claimed challenged the merits of the appraisal award, and the Eighth Circuit found it had no authority to reconsider the merits of an arbitration award, even when the parties alleged that the award rests on factual errors. An arbitrator does not exceed his or her powers by making an error of fact. Accordingly, the appraisers used the use of certain figures and measurements in calculating the amount of loss, and their alleged failure to consider particular buildings and portions of roof damage, even if incorrect, are not sufficient for vacatur under the Act. Since the parties bargained for the arbitrator's decision, if the arbitrator got it wrong, then that was part of their bargain. In my opinion, appraisal of the extent of loss in a first-party property insurance policy is an arbitration, as the Eighth Circuit found. Arbitration is designed to avoid or limit litigation. When an insured and insurer agree to appraisal by their contract in accordance with the terms of the policy, its award is binding on both parties, except in the case of fraud or of some other misconduct. Arguments over fact belong in the appraisal proceedings, and neither a state nor a federal court may place its evaluation over that of the appraisers. Martinique chose appraisal and must accept the findings of those appraisers. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. When you do so, you can subscribe to the blog and you will be advised of every blog posting, usually 5 a week, sometimes more. And you can also subscribe to the videos on rumble.com or youtube.com. If you found this blog posting and video to be of interest and use to you, please tell your friends and colleagues so that they can also subscribe to the blog post and or the videos. Thank you for your attention.